Good morning, ladies and gentlemen. I'd like to welcome you to County Court Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and the options that you have concerning your case. The case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. The felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they are not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of the state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Or if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you won't have to worry about those type of punishment. Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, Class C misdemeanors are cases that start in the city court or the JP court. They come to this court when a person is convicted in the JP court or the city court and they appeal their case. In essence, they get a hold of the trial and it comes to this court. Now, the range of punishment for a Class C misdemeanor is by fine only. You cannot be given jail time. You could be given a fine that does not exceed $500. Now, if you fail to pay the fine, or if the fine was converted to community service and you fail to perform the community service, then the court can issue what is called a capias pro fine. That means that there's a warrant for your arrest to either pay the fine or sit the fine out in jail. Now, if you sit the fine out in jail, then you'll be credited at $100 per day for every 1 day that you sit in jail. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county court, in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor. And the Class A misdemeanor range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for one of two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation, we normally refer to it as deferred adjudication. With that type of probation, you won't have a conviction on your record. And if you successfully complete it, you can get what is called a non-disclosure. A non-disclosure means that your record is sealed to the general public. Now, the opposite word is general public. Now, the general public, for example, could be like Exxon Mobil or some other non-governmental agency. Now, certain governmental agencies that are listed in the Code of Criminal Procedure can have access to it, but most of the public is general public, so most of the public cannot have access to that record. Now, the next type of probation is called adjudicated probation. You had unadjudicated probation, and the next type is called adjudicated probation. With adjudicated probation, we don't refer to it as regular probation. Now, it does result in a conviction on your record. However, if you successfully complete the probation, there's something that's called judicial clemency, where the court or the judge can set that conviction aside, and you no longer have a conviction. And in order to qualify, three things has to happen. One, you have to successfully complete the probation. Two, there cannot be any more time left on the probation. And three, the probation office has to successfully discharge you from probation. If those three things happen, the court has the discretion to set aside the conviction, and you no longer have a conviction. However, if you get a subsequent conviction, that is, if you get another conviction later on in time, then the case that you received judicial clemency on can be resurrected, revived, or brought back up and used against you. And if you try to get a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, everyone that's here for the arraignment, you should have a clipboard. I'm going to go over the paperwork that's on that clipboard. The first document, I'm not talking about the little short sheet, but the first document should be judge's explanation of rights to defendants without attorney. You need a clipboard?
Yes. You got one.
Yeah, okay. Thank you. Okay, the next one is titled Judge's Explanation of Rights to Defendants Without Attorney. And this document states that as a defendant in a criminal case, you have three options. And the first option is, this document talks about your right to have an attorney. Now, your first option is you can hire an attorney. Second option, number two, if you can't afford to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, the first one sentence paragraph below number 3 states that if you want an attorney, you can hire an attorney, and you can afford to hire an attorney, your case will be reset. Reset means you'll be given another court date from today to give you time to hire your attorney. Now, the second one sentence paragraph below number 3 states that if you want an attorney, but you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire. Now, so that the proper person can determine whether or not you qualify for court-appointed attorney. Now, the financial questionnaire is a 3-page document on that clipboard that is titled Jefferson County Affidavit of Injuries, or it's titled Affidavit of Injuries. You would have to fill out the entire first page of this document, And then on the second page, at the top, you will fill out the portion that says defendant's oath. And in the middle portion that's titled unsworn declaration by defendant. And then you'll stop. Okay, now going back to the first document, judge's explanation. The third paragraph is for people who will be representing themselves. In essence, they have a right to have an attorney that will be representing themselves. And that statement states that you may not talk to the prosecutor unless you first sign a written waiver of your right to have an attorney. Now, this is only for people who would be representing themselves. So if you're not representing yourself, you don't have to worry about what I'm getting ready to say. You would have to fill out this document that's titled waiver of counsel for purposes of entering a guilty plea or proceeding the trial. This document is also on the clipboard. This is only for people who will be representing themselves. You'll read this document, sign and date. Now, if we go back to the judge's explanation, there's a paragraph for people who will be representing themselves is in block form, right? And it states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. And the last one sentence paragraph states that if you choose to proceed without an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. Now, for those individuals who like to represent themselves, you'll have an opportunity to talk to one of the two prosecutors. Prosecutors or assistant criminal district attorneys that work for the Jefferson County District Attorney's Office. And the reason why you will have an opportunity to talk to them is because if you're representing yourself, you are your own lawyer. So just like a lawyer can talk to the prosecutors, you can talk to the prosecutors about your case if you waive your right to have an attorney. But as I mentioned to you earlier, you must first sign a written waiver of your right to have an attorney. Now, at the bottom of this document, in bold letters, it states defendant's choice, marking issues next to only one choice. If your choice is to hire an attorney to represent you, then you will place your initials on the first line to the left. Then you sign this document, date it, and then you'll stop. And this is the only document that you will have to sign. Okay, for those who will be hiring their own attorney. Now, if you've already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. Then you'll sign the bottom of this document that says defendant, date it, and stop. And this is the only document that you will have to sign. Now, if you would like to request a court-appointed attorney, then you'll place your initials on the third line to the left at the bottom. Then you will go to the Jefferson County Affidavit of Injuries. You will fill out the first page. And then on the second page, you'll fill out the top portion that says defendant's oath, in the middle portion that states unsworn declaration by defendant, and then you'll stop. Now, if you already have an attorney appointed to represent you, then you'll put your initials on the fourth line to the left, name of the attorney on the line to the right, sign this document at the bottom, date it, and then you'll stop. And this is the only form that you would have to sign. Now, if you would like to represent yourself, that is, waive your right to have an attorney, then you'll put your initials on the fifth line to the left at the bottom, and then you'll sign and date this form, And then you will sign the next document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You read, sign this document and date it, and then you'll stop. Okay? So just as a brief recap, if you are hiring your own attorney, if you already have an attorney that you hire, or if you have a court-appointed attorney, this is the only document that you're gonna sign. This is it, and then you stop. If you would like to request a court-appointed attorney, put your initials on the second line, on the third line on this document, sign and date it, and then you'll fill out this form, affidavit, Jefferson County affidavit, first page. And then the top portion that says defendant's oath, middle portion that says unsworn declaration by defendant, and you'll stop. If you would like to represent yourself, that is waive your right to an attorney, you're gonna place your initials on the fifth line of this document. The first document, sign, date, and then you'll go to this next document that's titled waiver of counsel for purposes of entering guilty plea or proceeding to trial. You'll sign this document, date it, and then you'll stop. Do we have any questions? Before we go, okay. Now, as I mentioned to you earlier, as a defendant in a criminal case, you have rights. One other right I would like to talk to you about is your right to have a trial by jury. Okay? Now, if you're in a plea of, say, not guilty, and that plea of not guilty means you're telling the court that you did not commit the offense that you have been charged with, you like to have a trial by jury. That area over there, we call it the jury box. 6 citizens from Jefferson County will be selected to sit as jurors in this case. And the reason why it's 6, because in a misdemeanor case, you have 6 jurors. In a felony case, you have 12. That's the only difference. So 6 individuals from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence. That is the evidence that's presented by the state, the evidence that's presented by the defense. They will listen to the arguments of the state and the arguments of the defense. And then they will go back into the jury room and deliberate. And they can find you either not guilty or guilty. Now, the next thing, you have a right to waive or give up your right to have a jury trial. By waiving or giving up the right to have a jury trial, you're telling the court that you don't want to have a jury trial. In essence, you will not have a jury trial, but you still can have a trial. You can have what is called a bench trial. It's a trial without a jury, and it's a trial by judge. The judge will be the judge and the jury in the case. The reason why they call it a bench trial is because the judge sits on the bench. So they call it a bench trial. Okay, now, the judge will listen to the evidence presented by the state and the defense, listen to the arguments of the state and the defense, and then the judge will apply the facts of the law and decide whether to find you not guilty or guilty of your charge. Now, you can waive or give up your right to have a trial altogether. In essence, you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting your charges. And if that's happened, then you and the state, or you and your attorney and the state can talk to the state to see if y'all can come up with what is called a plea bargain agreement. What a plea bargain is, nothing but an agreement to settle your case. Okay? Now, if, let's say you're representing yourself, and let's say you're interested in, you want to enter a plea, but you want to talk to the prosecutors to see if they can give you something that you like. Let's say you might like probation, okay? It needs to be deferred probation or regular probation. And your attorney talked to the state, or you talk to the state if you're representing yourself, and the state said, well, we're not offering probation, we're offering a fine. Or we're offering a jail time. Or we're offering jail time and a fine. And so you say, if you represent yourself, say, well, I don't want that. Okay, you have a right to withdraw your plea. In essence, what I'm saying, if you're saying you don't want it, then you can go to the judge and the judge can set the punishment. Okay, or if you want the plea, okay, let's say he came back for probation, you say, okay, I'll take that. It still has to come before the judge, and the judge can do one or two things. The judge can accept or reject that plea bargain agreement. If the judge rejects your plea bargain agreement, you can tell the judge, well, I withdraw, I take back my plea. And that's because I'm not pleading guilty in no contest because you're not accepted. You can do that. Okay, you say you have a right to withdraw or take back your plea. Now, if the judge does accept the plea bargain and say within 30 days, you would like to have a new trial or you like to appeal your case, then you would have to get permission from the judge that followed the plea bargain agreement. Now, if the judge give you permission to appeal your case will leave this court and it will go to another court. It will go to the Ninth Court of Appeals. They hear appeal cases. Okay. The Ninth Court of Appeals, guess what? It's right above us on the third floor. There's 4 judges up there. They will review your case to see whether or not you've been wrongly convicted, to see whether or not this court committed an error by convicting you. And they can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or they can send the case back down to this court with orders. Now, if they deny your appeal, then you can appeal it to a higher court than them, than the Ninth Court of Appeals. You can appeal your case to the highest criminal court in the state of Texas. It is called the Texas Court of Criminal Appeal. They're located in Austin, Texas. And there are justices there that will review the case to see whether or not your appeal should have been granted, or whether or not you were wrongly convicted, or whether or not this court committed an error by convicting you. They can do one or two things. They can grant or deny your petition. Now, you would have to file what is called a petition for discretionary review. What that means is this. It's a pro se petition for discretionary review. Pro se means self, by myself. And that's because you're not represented by an attorney. You're filing this petition on your own, petitioning them or asking them to review your case to see whether or not your appeal should have been granted, or whether or not this court wrongfully convicted you in error. They can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. Or if they deny it, then at that point, your conviction will stand. Okay. Now, another right that you have is your right to have witnesses to testify. Okay. Witnesses, they sit in that chair that has the microphone in front of it. We call that the witness stand. They can testify for you or against you. You represent yourself, you can ask some questions. If you have a lawyer representing you, your lawyer can ask some questions. We call that either direct examination or cross-examination. You can also waive or give up your right to have witnesses as well. And the other thing is you have a right to have discovery. The other right. What discovery is, you have a right to see the evidence. In essence, you have a right to see what's in the state's file. All the evidence that they have against you. Okay? You have a right to see your statements, witness statements, lab reports, police reports, right to see video recordings, photos, listen to audio recordings, to see documents or instruments, whatever evidence that they have, you have a right to have access to that. Now, you can waive or give up your right to have access to it as well. Now, when I was talking about your right to have witnesses, another right that you have is your right against self-incrimination. Fifth Amendment right against self-incrimination. The Fifth Amendment of the United States Constitution gives all of us a right to remain silent. In essence, the state, the government, the DA's office can't force you to take the witness stand and testify against yourself. If you invoke your Fifth Amendment right against self-incrimination. Now, it makes sense that you would have this right. Why? Because the state has the burden to prove that you are guilty beyond a reasonable doubt. You don't have to prove yourself guilty. Okay? So if you invoke your Fifth Amendment right against self-incrimination, you will not, they can't force you to testify. I know a lot of times we watch television, when we see television lawyer, you go up to somebody on the witness stand, ask them a question, they say, I take the fifth. That means I'm not saying nothing, I'm not testifying, I'm exercising my Fifth Amendment right against self-incrimination. Okay, now everyone that's here today, for this case, for your case rather, you have been charged, arrested, placed in the Jefferson County Jail. You're bonded out of jail. You're out of jail on either what is called a cash bond, which means you pay the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a bondsman a percentage of bail to get out of jail. Or you may be out of jail on what we call a PR bond or a personal cognizance bond, which means that you didn't have to pay anybody any money to get out of jail. You was just released under your own personal recognizance. I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So for example, the opposite word that I use is every day. So let me give you an example. Let's say last night around 11:59 p.m., you was booked into the Jefferson County Jail or booked into jail. And you bonded out at 12:01 a.m., 2 minutes later. That's 2 days. Why? Because it's 2 different days. You know, the day is not on the 24-hour basis, it's on the different day basis. You know, the day Tuesday, 12:59 last night was Monday. 11:59 last night was Monday, and 12:01 was Tuesday. So it's 2 different days. Okay? Now, every day that you spent in jail can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail. State is offering for you to serve 5 days in jail. That means you have to serve any more time in jail. Why? Because you already served 5 days in jail, so time that you spent in jail will be credited towards your punishment. We call that credit for time served. Now, if you spent 5 days in jail and off for 7 days, that means you only have to spend 2 days. Why? We subtract 5 from the 7, that leaves 2. Now, for every 1 day that you spend in jail, it goes towards your fine and court costs. So for every 1 day that you spend in jail, you get $100 per day. So if you spend 5 days in jail, that's $500. If the state is offering fine and court costs of $500, you don't have to pay anything. Why? Because the time that you spent in jail is already paid for. So therefore, you'll get what we call, your fine and court costs will be what we call tax and retire. Now, if they're offering $700 fine and court costs, you spent 5 days in jail, which is $500, you don't have to pay $200. Why? Because we'll subtract 500 from the 700, and it was 200. Now, you'll be required to pay the fine and court costs on the day that you take care of your case. If you cannot pay it, no problem, because we could put you on a payment plan where you can pay it off in small monthly installments. Now, if you do not have the income to pay it off in installments, no problem, because we can convert your fine and court costs to community service. And so for every 1 hour community service that you perform at a nonprofit organization in Jefferson County, Texas, you will receive $12.50 that will go towards your fine and court costs. So in One day you work 8 hours, that's $100. And so in our scenario, you work 2 8-hour days, that's $200, and you find the court costs is paid off. All right. Now, Jefferson County has a program for people who haven't been in trouble with the law before. They call that pretrial diversion. When I say Jefferson County, I'm talking about the district attorney's office. And the program is called pretrial diversion. With pretrial diversion, what they would do, they would dismiss your case. Okay, you get in the program, they'll dismiss your case. And if you successfully complete the program, you can get it wiped off your record. We call it expulsion. It's expunged, erased, deleted, or wiped off from your record. Now, in order to qualify, you have to have a lawyer to help you with the application process. And the lawyer could be a court-appointed lawyer. It don't have to be somebody you hire. And it has to be your first time getting in trouble with the law. And it cannot be for an offense involving resisting arrest, unlawful carrying a weapon. Okay, those two type cases, you don't qualify, but in any other cases, you can qualify. Now, this court, County Court Law Number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. It's an acronym. That is a program that God led me to start within the first 100 days of taking office in March of 2017. With that program, the program is designed to address the issue of what we call recidivism. Recidivism means people commit crimes over and over. And so with the program is to stop people from committing crimes over and over. And the way we do it is through the CSI program. And with the CSI program, we have partnerships with various agencies in our community. One of the agencies that we have a partnership with is the Spindletop Center. It's our local mental health center in the Southeast Texas region. And we have some folks from Spindletop here. They're going to come and talk to you a little bit later. But basically what Spindletop will do, Spindletop will conduct a private interview either in our jury room, at their facilities, or by telephone, or whichever is convenient to you. Then they will do an assessment to determine what your mental health issue may be. And then 3, they would develop a treatment plan to treat your mental health issue. Okay? Now, in order to qualify for the program, you don't have to be incompetent or insane. You can just merely suffer from depression, anxiety, or any other host of mental illnesses, and they have the expertise to address your mental issue. Now, if you have an issue, if you have a problem with drugs or alcohol, then Spindletop has a program that is called ATAR, A-T-A-R. It's an acronym that stands for Addiction, Treatment, and Recovery. And with that program, what they will do, they will do an assessment. They will do a screening and assessment, and then develop a treatment plan for either outpatient or inpatient treatment. Now, we also have that same program with our local drug and alcohol council that's called, and they have a program called OSAR. OSAR stands for Outreach, Screening, and Referral. Now, if you are looking for a job or looking for a better job, we have a program with the Golden Triangle. We have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE, and it stands for Center for Commercialization or Entrepreneurship, Commercialization, and Entrepreneurship. Okay, so with the CICE program, they will train you in either one of the fields of either the shipping industry, the chemical industry, or the hotel industry. Once you're trained in any one of the industries that you select, they will help you to get a job in the area that you're trained in. If you do not have your high school diploma or a GED, well, they have a GED program where you can receive your graduate equivalency diploma. Now, all of those programs that I've just mentioned are free. Does not cost you anything but time. And like I said in this court, we don't just give time. We take our time. And that simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crime. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we try to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community because what comes out of the home goes in the community. And so if you're interested in any one of these programs that I just mentioned, just let us know. We can get you started on living your best life. So at this time, as I mentioned to you earlier, we have some folks from Smithtown Center. And they're gonna come and tell you a little bit more about the program that they have to offer. We have Caitlin and Deputy Neville.
Morning, how you doing? I'm Josh, with the Sheriff's Office. I'm assigned to the mental health section of our division. I'm partnered with Caitlin here. She's a qualified mental health professional with Spedify and the campus school information packets we sent out. If you fill them out, she could probably explain that a little bit more detail than I can. Probably not her.
So at the front of your clipboard should be like a little half paper. That form is optional. You do not have to fill it out. It is not a court document. It is for us. And whatever you put on there, I don't tell the judge or anybody else in the court. It's protected between us with HIPAA. So it's basically to get you and connect you with resources that you feel that you might need. We have mental health options, which is depression, anxiety, or PTSD. We can get you in with a doctor to talk about medications. We can connect you with a counselor or a therapist, anything like that. And then we have a substance use program, which is any type of drugs or alcohol. We have a support group and we have support classes. And if there's a resource that you've heard of that we don't offer, we can also help you try to find that resource somewhere else, whether it be in the area or in Houston. Again, you don't have to fill this out. You can leave it blank if you want to. You can turn it in. If you already put it out and you don't want to turn it in, you can dispose of it yourself, or you can tell us to throw it away for you. If you have any questions or you want to talk about services today, please write on that little paper. Please talk to me today, and I'll kind of pull you to a private room where we can talk, and then you can see the judge before or after that. But either way, we'll try to work it in so you do your best. Okay.
Okay, thank you, Caitlin
Thanks, sir.
and Deputy DeVille. Now, ladies and gentlemen, the paperwork that you have on the clipboard, I'm gonna give you time to finish filling out. We're going to pick up that paperwork from you. And then we're gonna put you into one of 3 categories when we call you up before the bench. One category is you want to hire an attorney. And if you want to hire an attorney, your case will be reset today. And then once we reset your case, you get your paperwork, you'll be free to go. The next category is for individuals who would like to apply for a court-appointed attorney. And if you'd like to apply for a court-appointed attorney, if you qualify, the court-appointed attorney will be appointed today before you leave. Once that happens, then you'll be able to leave the courtroom as well. And the last category is for individuals who like to represent themselves. If you would like to represent yourself, then you have an opportunity to talk to one of the prosecutors. And if y'all come to an agreed plea bargain, case will come before the judge. If the courts follow plea bargain, that case will be taken care of today. Okay, now, we're gonna pick up the paperwork. If you need help with any of the paperwork, we have our court personnel, including myself, who will be happy to help you. While we picking up this paperwork, it's gonna take us a little time to pick it up. We're gonna try to get you out of here as soon as possible. If you need to use the restroom, there are two restrooms that are right outside the courtroom in the hall. The men's restroom is in front of County Courthouse Law number 3, and the women's restroom is on the opposite side of the hall, in front of the 172nd District Court. You'll be allowed to use the restroom. Please do not leave the courthouse. If you leave the courthouse, your name is called, warrant gonna be issued for your arrest, you're gonna be arrested. And guess what? We're gonna have to go through this all over again. Okay? So, we're gonna try to, get through this as soon as possible. Again, if you need some help, just make sure that you raise your hand. And again, ladies and gentlemen, be mindful, even though we'll be out in the gallery, picking up paperwork and going over this stuff, which you still in court. So conduct yourself accordingly. Okay? Do we have any questions? No questions? Okay. The court will be in recess.
And good night. You take it, but on top, I'm not sure if you voted, but on top of the first,
Ms. Washington. Your full name is Marjorie Concepcion Washington?
Yes.
Ms. Washington, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Washington, you may put your hand down. How are you doing, Ms. Washington? Doing good? That's good. Ms. Washington, I have before me a document that is titled Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to hire your own attorney? Before you sign and initial this, Ms. Washington, Ms. Washington, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Ms. Washington, your case is going to be reset to give you time to hire your own attorney. Our court coordinator is going to give you your reset. Please have a seat in that first chair on the wall and wait for your name to be called. Eon Lee. Mr. Lee, did I pronounce your first name correctly?
Ian.
Ian.
Yes, sir.
Okay. Mr. Lee, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Mr. Lee, you may put your hand down. How are you doing, Mr. Lee?
sir.
That's good, Mr. Lee. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, Mr. Lee, before you sign this document, did you read this document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Lee, your case is going to be reset to give you time to hire your attorney. You're going to get your reset from our court coordinator. Before she gives you that reset, I need to hand you a document that is titled Standard Bond Conditions. You can please step back in front of the bench. The document is titled Standard Bond Conditions in County Court Law Number 2. And it states, following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Let's see, this is a discharge. Condition number 3 and 4 does not apply. However, condition number 5 does apply, and it states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, if you violate any one of these conditions, the bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Okay, please have a seat on that. Oh, stand in front of the court coordinator, get your reset. Once you get your reset, you're free to go and you have a blessed day. Mr. Morrell, your full name is Max Christian Morrell?
Yes, sir.
Mr. Morrell, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Morrell, how are you doing? I'm doing fine, thanks for asking. Mr. Morrell, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states that you have hired Rife Kim?
Yes, sir.
Now, Mr. Morrell, before you signed and initialed this document, did you read it?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Morrell. I read your answers. You're gonna stand in front of our court coordinator. She's going to reset your case. Once she resets your case, you'll be free to go. Let's stay in contact with your attorney and your bondsman.
Yes, sir. Yes, sir.
Thank you. Christopher Gutierrez. Mr. Gutierrez, your full name is Christopher Gutierrez. Mr. Gutierrez, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Gutierrez, you may put your hand down. How you doing, Mr. Gutierrez? You all right? Now, Mr. Gutierrez, I have before me two documents. The first document is titled Judge's Explanation. Well, actually, it'll be one document. You don't need this one. This document is titled Judge's Explanation of Rights to Defendants Without Attorney. And do you recognize this document?
Yeah.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to hire your own attorney? Before you signed and initialed this document, did you read it? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Gutierrez, read your answers. Your case will be reset to give you time to hire your attorney. Our court coordinator is going to reset your case. Once your case is, well, he has another one. There's two cases. Yeah. Also, before she resets your case, I need to give you some bond conditions. Ms. Mosley. Okay, now, Mr. Gutierrez, the document that you have is titled Standard Bond Conditions in County Code Law Number 2. Do you see that document?
Yes.
Okay, and it states, following return of accruing information in County Code Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to that additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yeah.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. Court may revoke the bond and order the arrest of any defendant who A, refuses to submit to drugs and alcohol, a test for drugs and alcohol, when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Yes, sir.
Now, condition number 3 and condition number 4 does not apply. However, on the next page, condition number 5 does apply. And condition number 5 states, defendant is prohibited from possessing a firearm or ammunition as defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Gutierrez, if you violate any one of these conditions, your bond can be revoked. If your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? Okay. Mr. Gutierrez, you're gonna have a stand in front of the court coordinator, get your reset. Once you get your reset, you're free to go, and you have a blessed day.
Thank you.
Leah Nicole Cormier. Ms. Cormier, your full name is Leah Nicole Cormier?
Yes, sir.
Ms. Cormier, would you please raise your right hand and you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may put your hand down. How are you doing, Ms. Cormier?
I'm blessed. Thank you.
It's good. I'm blessed as well. Now, Ms. Cormier, I have before me two documents. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled?
Yes.
Are these your initials that state you'd like to apply for court-appointed attorney?
Yes.
On the next document, that is titled Jefferson County Affidavit of Indigence, do you recognize this document?
Yes.
On page 2 of this same document, there's a set of, well, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Ms. Cormier, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Ms. Cormier, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And let's see. The attorney that will be appointed to represent you in your case is Attorney Don Boudreaux. And Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
Let's see. Joanna Grace Janae Momon. Miss, your last name is Momon?
Yes.
And what's your, how you pronounce your first name?
Johanna.
Huh?
Johanna.
Johanna, okay. Now, Miss Momon, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may put your hand down. How are you doing? I'm doing fine, thanks for asking. Now, Miss Momon, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to apply for court-appointed attorney? On the next document, that's titled Jefferson County Affidavit of Indigence, do you recognize this document? On page 2 of this same document is a signature above the line that is titled Defendant's Signature. Is this your signature? Okay, Ms. Moman, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Moman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. But before I give you that information, I need to give you some bond conditions. Bailiff is gonna hand you a document that's titled Standard Bond Conditions in County Code of Law number 2. Do you see that title? Okay, I'm going to go over this document with you. And it states, following return of a criminal information in County Code of Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Yeah. And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you know who the victim is?
Read the court's indulgence, Judge.
Oh,
Victims, Carson Trent Williams.
Carson Trent Williams.
Thank you, Shane. Yes, sir.
Trent.
Let me do this here. Do you understand that condition? Okay. Now, condition number 4 does not apply. Condition number 5 does apply. States defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition? Now, Ms. Mormon, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay, now our court coordinator is going to reset your case. Again, you've been appointed on Burbank. Mr. Burbank is going to be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. You have a blessed day. Stay in contact with your attorney and your boss. You have a blessed day. Please have a seat in the chair on the wall. Okay.
If your attorney's name, Thomas Barney, is your next court date?
Walter Brown.
This is information. This is. Me too.
Mr. Brown, your full name is Walter D. Brown?
Yes, sir.
Mr. Brown, would you please raise your right hand? Do you swear firmly to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Brown, you may put your hand down. How are you doing, Mr. Brown? I'm doing fine. Thanks for asking, Mr. Brown. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you like to apply for court-appointed attorney?
Yes, sir.
I have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, it's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Brown, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Mhm.
Okay. Now, Mr. Brown, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Giles Cole. Attorney Cole will be given information to contact you. And you will be given information to contact him. But before I give you that information, I need to give you some bond conditions. And I'm going to go over those bond conditions with you in about a minute. Okay, Mr. Brown. You have before your document that is titled Standard Bond Conditions in County Court at Law Number 2. And it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And we know who that victim is.
Not what's the bond amount city?
I don't, my computer, I think just went out. Computer.
Mine is getting like, on the slow side too.
Man, I don't know what's wrong with this computer. Let me see.
I'm gonna invite you, Judge. Checking out to see where it was, Isabel. Patricia Brown, Judge.
Okay. Okay, I'm looking
That's
at it.
I'm sorry, Judge. I think it's Willis. Well, Tiana Brown. I shouldn't say that. That's
I know what you're talking about.
15.
Yeah. Okay, let me do this here. I have before me a document that is titled, two documents. One document is titled Judge's Explanation of Rights of Defendants, and the other document is titled Jefferson County Affidavit of Injuries. Now, on the judge's explanation, you recognize it? Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. Now, how are you doing? You all right? That's good. Now, Ms. Hamilton, is this your signature on the line that's titled Defendant on the judge's explanation? And are these your initials on the line that state you like to apply for an attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Ms. Hamilton, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best? Ms. Hamilton, based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Attorney DeLodge will give information to contact you. You will also be given information to contact her. Our court coordinator will give you that information. Once you get that information, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall and wait for your name to be called. Charles. Mia Rhines? Is that Maya? So your full name is Maya Javon Rhines?
Yes.
Okay, Mr. Rhines, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing, Mr. Rhines? That's good. And Mr. Rhines, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that state you would like to apply for a court-appointed attorney? And I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? There's a signature above the line that is titled Defendant Signature on page 2. Is this your signature?
Yes.
Now, Mr. Rhines, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Mr. Ryan, I read your answers. Based on your answers, hold on, wait a minute. Yeah, based on your answers, meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall and wait for your name to be called. There you go. Jermaine Patton. Mr. Patton, your full name is Jermaine, okay? Mr. Patton, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing? That's good. Now, Mr. Patton, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line as titled defendant?
Sir.
Or these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Do you recognize this? Is this your signature?
Yes, sir.
Now, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Now, Mr. Patton, let me do this. I need to ask you. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Jones, you may put your hand down. How are you doing, Mr. Jones?
Senator, how are you doing?
I'm doing fine. Thanks for asking. Now, Mr. Jones, um, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes, sir.
I also have another document that's titled Jefferson County Affidavit of Injuries. And do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Jones, I see here. Let me do this here. Turn this off.
Okay, let's see. See James.
The amount of money that you make, you don't qualify for a court-appointed attorney.
No,
No, so you have two options. One, you can have your case reset to hire, we'll talk to the lawyers, hire your own attorney, or you can waive your right to an attorney and represent yourself. Okay? Those are, because you don't qualify for court-appointed attorney.
but too much.
Yeah, you make too much. Well, yeah. Okay.
Mo,
Wait.
Right.
So, Miss Mos. You can get his, Back to it. yes.
I just want this done as easy as possible. I mean, I don't care if I had to pay it or not, you know,
Okay.
just,
I can't give you any advice.
okay.
You have three options
Yes.
regarding your right to have an attorney.
Mm.
You need to hire one. You can apply, well, you didn't qualify for a court-appointed
Yeah.
attorney. And number three, you can waive your right and represent yourself. So
My phone.
those are your three options.
I'm sorry, I didn't know there was a limit. I mean,
Yeah, well, that's why we have this financial form.
yeah, okay.
Yeah. If you know, yeah, okay. So this case, so you wanna, your case reset to hire your own attorney, is that correct? This is Mr. Jones, Jared, hi, Jared, Jared Jones. Okay, Mr. Jones, your case is gonna be reset to give you an opportunity to hire your attorney. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go. You have a blessed day.
Thank you, sir. You too.
Thank you. Okay, now we have Mr. Brown. This will conclude the calling of the court's arraignment docket in County Court Law Number 2 on January 2026. Judge Terrence L. Holmes presiding. Prosecutors, you are free to go. Everyone, please have a blessed day.